All right, very well. I'm going to call to order our conference committee on Senate File 970. Today is May 4th, 2021. This hearing is being conducted, at least on the House side, under House Rule 10.01. Some of the rules with our Senate colleagues that allow us to use an electronic platform during the COVID-19 pandemic in order to acknowledge social distancing for public health reasons. The public can view this conference committee via streaming video. I believe that's available on both the Senate and the House websites, as well as you can visit our web pages to view the rule under which we're convening. Excuse me, members, this is the second meeting of this conference committee. And very quickly, I don't want to presume in this platform, Chair Limmer, I'm still, after all these months, still adjusting to this, but I just want to make sure that all our members can state that they're here so that the public knows that they're here. So obviously I'm here, Representative Mariani. Senator? Oh, you're muted.
I'm here. I am not a robot. I'm participating in the whole discussion. So we can move on to Senator Ingebrigtsen.
Good morning, members. Looking forward to going through the articles.
Vice Chair Fraser present.
Senator Andrew Matthews, I'm here.
Chair Jamie Becker-Finn here.
Ron Latz here. Good afternoon.
Representative Kelly Muller, reporting for duty.
Senator Mark Johnson, here and present.
And Representative Tim Miller.
I think that rounds us out, Chair Limmer. Welcome, everyone. Looking forward to today's conference time together. Excuse me. Let me start off just by, officially calling us to order. Just to do some very quick housekeeping announcements. The first one is to let you know that today's agenda, we've posted it, is to have a walkthrough by nonpartisan staff of the House bill. Yesterday we heard the Senate bill presented, and we'll have several of our House Research Department members do that. And then after that, we're going to hear from some commissioners and additional testifiers in support of key policy provisions in the bill. And I'll explain that when we get to that point in time. And then the third item on our agenda is for the House to present an offer to the Senate. And I'll be asking my colleague, Chair Becker-Finn, to walk us through, those provisions. And then we'll adjourn. And per rules, we can't do that no later than 4 p.m. So Senator Ingebrigtsen, you're probably going to get that shot going outside and enjoying the good weather.
Great, thanks.
You bet. So members, just very quick housekeeping announcements, at least from the House side. We will have the gavel again on Thursday. And at that point, what we want to do is share very specifically the police policy proposals in this bill. There are several proposals that are looking to improve systems of good policing and facilitate change in our systems to make that possible. So we're going to walk through those provisions at that time. We'll hear from those directly impacted by current practices, as well as those who would be impacted by some of the changes for enhancing our policing systems in our state. Well, so it'll be an opportunity for the House to more carefully go through, entertain questions and conversation with our colleagues in the Senate. And most likely we'll be sharing an offer at that point as well, specifically on that issue. So, so that's it on my end. I don't know, Senator Chair Limmer, if you have any housekeeping things you wish to share at this time. I certainly would invite you to do so.
Thank you, Chair. I really don't have anything more to add. It's, of course, it's your day. And so we'll sit back and enjoy your presentation. And of course, I'm sure you'll have it open for questions if we have any as we progress, or do you want us to hold any questions till the end of the program?
Yeah, fair question. Why don't we hold to the end? That seemed to work well yesterday when we heard the set of provisions. That way, we're not breaking the timing of our nonpartisan staff, and then also we can make sure that even though it's pretty quick testimony, that we'll get those testimonies in.
Okay.
All right, very well. Thank you. So with that, members, we're going to have our staff walk through the House bill. And I don't know the order, but we do have Mr. Ben Johnson, Mary Mullen, and Jeff Diebel from our House Research Department who will do that.
Mr. Chair, this is Ben Johnson. I'll get things started.
Very well. Welcome.
Mr. Chair, Conference Committee members, it's Ben Johnson from House Research. I'm going to start the walkthrough. We're going to be moving fairly quickly at a relatively high level on many of these provisions given the length of the bill, and we'll bounce back and forth a little bit. When we're handing it off to somebody else, we'll ask that you recognize the other person. I'm going to start with Article 4. I'll be loosely tracking the side-by-side. We're going to start with Section 1. Section 1 establishes a new judge unit in the 5th District. This is based on changes related to the criminal sexual conduct laws. The Senate has the identical provision. Section 2 requires the court to appoint counsel to represent each parent, guardian, or custodian who desires counsel and who is financially eligible for certain child protection proceedings. The Senate is carrying this policy in their Health and Human Services Omnibus bill. Section 3 provides that a federally recognized American Indian tribe and their attorney can appear and file documents without paying a filing fee if the case they're participating in is for child support, paternity, civil commitment, public guardianship or conservatorship, or juvenile court or child protection matters. Section 4, which appears on R3 of the side-by-side, modifies the process for allocating county program aid related to court-appointed counsel. As mentioned yesterday, the Senate has comparable, I believe, in fact, it's identical language. Section 5 amends the distribution of fines, penalties, and forfeiture collected by the court administrator by providing that as of July 1st, 2022, every municipality or subdivision of government within Ramsey County shall receive 2/3 of the money, with the balance going to the general fund. Currently, municipalities other than St. Paul receive 50% of the money, while all other municipalities in the state receive at least 2/3. Section 6 establishes an exception to the 2-year limitations period on filing a petition for post-conviction relief for certain persons who are in immigration removal proceedings. Section 7 provides that court-appointed counsel may file an application with the district court to pay for interpreters used in meetings that take place outside of court and are necessary to prepare an adequate defense. Sections 8, 9, 10, and 11, which begin on page R6 of the side-by-side, shift the responsibility for appointing counsel in certain cases from the district courts to the chief public defender. As mentioned yesterday, the Senate has identical provisions. Mr. Chair, that gets us through Article 4. I'm going to move on to Article 5. The first 3 sections of Article...
Could I ask Mr. Johnson to give me one more time what page or papers you're going off of so I can follow along for reference? That would be helpful.
Mr. Johnson.
Senator Matthews, I'm walking through the side-by-sides that were prepared. So there should be a side-by-side posted. I'm going to move to Article 5 of the side-by-side, and at the bottom of those side-by-sides, there are page numbers that start with R.
Okay. Article 5, victims, criminal defendants, that's the heading?
That's correct, Senator.
Okay. Thank you, Mr. Chair.
Of course. Proceed, Mr. Johnson.
Mr. Chair, moving on to Article 5. The first three sections of Article 5 clarify provisions of the Safe at Home program, including identifying what mail will be forwarded, who must use a designated address for a participant, and when landlords are prohibited from publicly posting the name of a resident who is a program participant. This was contained in a Senate bill, Senate File 2106, that did pass the Judiciary Committee but has not gone to the floor. Mr. Chair, sections 4, 5, 6, and 7, which begin at the bottom of page R2, address the court's ability to waive the $75 surcharge imposed on all criminal and traffic offenses. Waiver can happen for defendants who are indigent or where the court determines that the surcharge would impose a financial hardship. Section 8, which is on page R5 of the side-by-side, establishes time limits for law enforcement agencies to process a request from victims of crime to provide a certificate indicating that the person is a crime victim. Those victims must provide certificates to federal immigration authorities to support their requests to remain in the United States under a U visa. Section 9, which is the final section in Article 5, requires prosecutorial offices to collect data on their use of jailhouse witnesses. It also directs the Attorney General to maintain that data and report summary data describing the use of those witnesses. It requires prosecutors to disclose specific information to defendants and their counsel, and requires prosecutors to notify victims if a defendant is offered a plea agreement in exchange for agreeing to testify against another person. Mr. Chair, that gets us through Article 5. I'd ask that you recognize Mary Mullen to continue with Articles 6 and 7.
Very well. Welcome, Ms. Mullen.
Hi, Chair and members. This is Mary Mullen with the House Research Department. I'm going to be walking through the Judiciary and Public Safety side-by-side labeled Human Rights Article 6. It starts on R1 of that document. Section 1 adds a new section to the Minnesota Government Data Practices Act, creating a cross-reference to indicate access to data on certificates of compliance are governed by existing rules that are in the Data Practices Act. Section 2 prohibits a health plan from providing coverage for anatomical gifts and organ transplants from denying eligibility or coverage based on a person's disability. This was also carried in the Senate HHS Omnibus bill. Article 19, Section 1 in that bill. Section 3 adds a protected class of familial status to the public policy statement in the Minnesota Human Rights Act. It is currently a protected class, but it's not in the public policy statement of that act. Section 4 directs the commissioner to solicit, receive, and compile reports for community organizations, schools, and individuals regarding crimes that members of the community believe are motivated by bias. Section 5 updates language used in the section of the Minnesota Human Rights Act that requires an employer to make reasonable accommodations for job applicants when the individual has a disability and requires them to engage in an informal interactive process. Section 6 prevents employers, including labor unions and employment agencies, from requesting a job applicant's pay history. Sections 7, 8, and 9 prohibit discrimination in housing against an individual who's receiving public assistance. Section 10 clarifies that a person can file a charge with the Department of Human Rights about discrimination online. Section 11, which you can find at the bottom of R8, if you're following through on the side-by-side, allows a person to bring a discrimination claim to request reconsideration on a determination that no discrimination was found within 30 days after the determination is issued. And then it also allows the respondents 30 days to request reconsideration as well. Sections 12 and 13 also clarify that a person can file with the Department of Human Rights for discrimination claims online. Section 14 updates requirements and applications of certificate of compliance for public contracts, clarifying applications to the application of that section to the Metropolitan Council, and updates language related to the application of affirmative action plans and removes some obsolete language. Section 15 increases the filing fee for certificates of compliance. Currently it's $150. It would go up to $250. And the Senate does have an identical provision to this in Article 2, Section 3. Section 16 allows the Commissioner of Human Rights to impose a fine for violations of certificate of compliance, and it allows the Commissioner to suspend or revoke a certificate of compliance if the fines are not paid. Section 17 makes conforming changes. On the bottom of R13 now, we're on to Section 18. Section 18 provides that data related to certificates of compliance submitted by a business is classified as private data on an individual or non-public data when it doesn't relate to department employees. Section 19 increases the filing fee for an equal pay certificate. Again, they were $150 under current law. The bill would be to increase it to $250. And this same language is found in the Senate bill at Article 2, Section 4. Section 20 allows the Commissioner to issue a fine for a lack of compliance or suspend or revoke an equal pay certificate when the fine has not been paid. Section 21 deals with data related to equal pay certificates, and it provides that the data related to an equal pay certificate submitted by a business is classified as private data on an individual or non-public data when it doesn't relate to a department employee. Section 22 prohibits discrimination by healthcare providers or anatomical gift donation matching organizations from discriminating based on a person's mental or physical disability in accessing the list for a transplant. And that is the end of the Article 6 Human Rights section. I'm going to move on to another side-by-side that's posted called Article 7 Civil Law. And that also starts on its own page R1. Section 1 allows a notary to charge a larger fee than allowed to notarize a document to perform a wedding. Currently, a notary can only charge $5 for their services. There are other sections of this bill that allow a notary to perform a wedding ceremony, and so this would allow them to charge a higher fee. Section 2 provides that notaries have the power to perform a civil marriage along with other powers notaries are granted when they have a valid notary commission. Section 3 authorizes a notary to solemnize a marriage if they have registered their notary commission with the local registrar in a county and they fulfill the technical filing requirements, which mirror the requirements for a religious officiant. Section 4 replaces the existing process for removing an occupant from a storage unit that has failed to make a payment or for other breaches of the contract. It provides that if a person's defaulted on their rent for their storage unit, the owner can start an action to remove the person's belonging from the storage unit using a court process that has limited filing timelines. Section 5 adds notaries to the list of individuals who can perform a civil marriage. Section 6 replaces the existing law allowing one party to a marriage to apply in person for another person to provide a notarized statement attesting to the application and proof of age, with a provision that would allow the parties to do the oath virtually and accept electronic filings for the marriage license application. This was a temporary provision that was implemented last year, and this would be retroactive because of that, because it would be continuing that provision into the future. Section 7 amends a temporary harmless error rule that was passed in 2020 so that it no longer expires on February 15th, 2021, and would make it a permanent part of the probate code. This is also identical to Senate File 258, which passed in the Senate. Section 8 provides that an action for damages based on sexual abuse may be brought at any time in a case where the alleged sexual abuse occurred from a police officer. It makes the elimination retroactive for a period of a few years. Section 9 provides that an action for damages based on wrongful death may be brought at any time in the case of alleged act by a peace officer, and it also creates a brief retroactive period for time-barred cases. Section 10 creates a temporary provision passed in 2020 related to filings under 336B.02. These are security interests on utility or taconite companies, and it extends that out to June 30th, 2022, instead of allowing it to expire on December 31st, 2021. And there is a Senate bill that passed in the Senate, Senate File 1807, that was identical to that provision in Section 10. And that is the end of the civil law article.
Very well. So someone else is jumping in, is that right?
I think Ben Johnson will be doing the data practices section.
Very well. Mr. Johnson.
Mr. Chair, Ben Johnson again from House Research. I'll go through Article 8 next. Article 8 is titled Government Data Practices. Again, I'll be referring to the side-by-side for some page numbers as we go. Section 1 reestablishes the Legislative Commission on Data Practices and Personal Data Privacy. It was established in 2014 and expired. As mentioned yesterday, this is substantially similar to the language in the Senate bill. Sections 2, 3, 4, and 5 all amend data provisions related to the Safe at Home program. Changes include amending definitions, establishing how a program participant can notify a government entity of participation in the program, making technical changes regarding the classification of data and data sharing, permitting government entities to amend official records to protect a participant's address or other location data, and sharing a participant's identity with other government agencies, entities, in conjunction with real property records for purposes of administering assessment and taxation laws. As mentioned previously, these provisions passed the Judiciary Committee as part of Senate File 2106. I'm going to skip to Section 8 because that's the next section that appears in the side-by-side. It's on page R6 of the side-by-side. This section creates a cross-reference within the Government Data Practices Act for the new provisions that are related to data on individuals who are minors. The Senate has a similar position in Senate File 672, which passed the Senate. Moving back now to Section 6, which is also on page R6. This allows private educational data to be disclosed to tribal nations about tribally enrolled or descended students. Section 7 makes a conforming reference in Chapter 13 to data collected and maintained by the Attorney General regarding jailhouse witnesses. Section 9 classifies mental health data and identifies when law enforcement can obtain and share that data. Sections 10 and 11, which start on page R9 of the side-by-side, make changes in the police body camera statute. They correct a typo in the automated license plate reader statute and add requirements that biennial audit reports also be sent to the relevant legislative commissions. This was contained in Senate File 1614, which is currently on general orders in the Senate. Section 12 addresses the statute concerning data maintained by the Ombudsperson for Corrections and clarifies that the enumerated categories of data are public only for closed cases. Section 13 is the related provision for data on individuals who are minors. It classifies as private the enumerated kinds of data that the Department of Natural Resources collects, creates, receives, maintains, or disseminates about known minors. As mentioned previously, this is identical to Senate File 672, which passed the Senate. I said identical, it's actually, there is a slight difference. It's similar to that provision. Section 14, which is on page R11 of the side-by-side, changes and limits who may obtain an individual's certified birth or death record. This provision is being carried in the Senate's Health and Human Services Omnibus Bill. Section 15 is the last section in Article 8. It's related to the reestablishment of the Legislative Commission on Data Practices. As mentioned yesterday, it is substantially similar to the Senate language. There's a different method of appointment and different provisions regarding payment of members. Mr. Chair, that's the end of Article 8. I'm going to move to Article 9. Article 9 deals with forfeiture. I'm not going to go through this article section by section. I believe both committees have heard this bill at this point, so I'm going to give a very high-level overview of this article. It makes several changes to Minnesota's forfeiture laws, including limiting the types of offenses that can result in a DWI forfeiture, limiting the types of property that is subject to forfeiture under the controlled substances provisions, establishing a process for an individual to present an innocent owner claim, reducing the burden on individuals claiming to be innocent owners, requiring law enforcement agencies and prosecuting authorities to report on each forfeiture and on the use of money obtained through forfeiture, and directing the state auditor to conduct a study on the efficacy of both forfeiture and the ignition interlock program on reducing recidivism in DWI offenders. Mr. Chair, that's the very high-level overview of Article 9. I'd ask that you now recognize my colleague, Jeff Diebel, to walk through the next 4 articles.
Thank you, Mr. Johnson. Mr. Devo, welcome.
Good afternoon, Mr. Chair and committee members. I'll begin with Article 10, which is entitled Policing. Section 1 is a piece of the Post Board's agency bill, and it relates to how they classify certain data on peace officers. Section 2 is a conforming change related to a bill that Representative Frazier is carrying, House File 1374, which provides for certain private data on peace officer complaints to be submitted by chief law enforcement officers to the Post Board. Moving on to Section 3 and 4, these are from Representative Moeller's bill on which would prohibit police officers from stopping drivers for certain non-moving violations. They would no longer be considered primary offenses, which would form the basis for a stop. Section 5 is another piece from the Post Board's agency bill, and it reforms the Post Board's complaint review process, committee process, to conform with changes that were adopted last summer by the legislature and how the complaint committee is comprised. Section 6 is another piece of the aforementioned bill from Representative Frazier on providing private data. This requires the Sentencing Guidelines Commission to collect certain data on probation practices in the state. Section 7 is Representative Hollins's proposal to regulate and restrict the use of no-knock search warrants. Moving on to Section 8 of Article 10. This is from Representative Hornstein's bias crimes bill, and it deals with the training that police officers receive on investigating bias crimes. Section 9 is an additional piece from the Post Board agency bill, and this clarifies that board positions are subject to requirements of Chapter 214 regarding when the terms of the officers are expire and when they renew. Moving on to Section 10, this contains proposal language from 2 separate bills. The first is from Chair Mariani's House File 729, which renames the Ensuring Police Excellence and Improving Community Relations Advisory Council, which the legislature created last summer, and provides a new name, which is the Peace Officer Standards and Training Board Citizen Council. Another small piece is from the Post Board's agency bill, and this clarifies that the Minnesota Ethnic Councils are responsible for appointing members, that they're responsible for appointing certain citizen members to the Post Board Citizen Council. Moving on to section 11. This is a conforming change related to Representative Frazier's bill on private data on peace officer complaints. Section 12 is another piece from Representative Hornstein's bill on bias crimes. And again, it relates to training police officers receive. Section 13 is from Representative Frazier's. This is the substance of Representative Frazier's sharing certain private peace officer data on complaints with the post board. This is an expansion of the proposal that was enacted last summer regarding sharing public complaint data with the post board, and also there and through on to the Citizen Council. Moving on to section 14 of Article 10. This expands the scope of the annual compliance reviews that the post board is obligated to perform on each law enforcement agency in the state. Section 15 is an additional piece related from Representative Hornstein's bill on bias crime reporting and investigation. And this requires, again, it gets to the issue of police training and post-board participation in that training and development of coursework. Section 16 requires the post board to create a list of approved trainers and training courses related to peace officers responding to individuals with mental illness or Alzheimer's. Section 17 modifies the body camera policy requirement in Chapter 626, and it adds additional requirements to be included in the body camera policies adopted by agencies that do operate a body camera program and outfit their officers with body cameras. Section 18 modifies the duty to intercede and report, which was enacted last summer by the legislature. And it's this is the duty to report excessive force by another officer. It adds a requirement, or adds a potential sanction if for failure to do so, which could lead to discipline by the post board if someone fails to comply with the duty to intercede and report. Section 19 was discussed yesterday by Mr. Backus. It is almost identical to the Senate proposal on confidential informant model policies that need to be adopted by law enforcement agencies in the state. Section 20 is another model policy proposal. This is Mueller's proposal on human trafficking model policies to be developed and adopted by the agencies throughout the state. Section 21 is an additional model policy proposal which relates to the development of a model policy on public assembly response and requires agencies to adopt a conforming policy, and that was authored by Chair Mariani. Section 22 and 23 are from Representative Gomez's Citizen Oversight Council bill, House File 640, and this authorizes local units of government to create citizen oversight councils for their law enforcement agencies. Section 24 is a proposal from Representative Becker-Finn, and it provides that the Band of Ojibwe concurrent jurisdictional law enforcement authority with the local sheriff within the boundaries of the tribe's reservation. Section 25 is an increase in salaries for certain law enforcement officers who are employed by the state. This is in response to the increase that was provided last year by the legislature to other law enforcement officers employed by the state. Section 26 is a final piece from the Post Board's agency bill, provides rulemaking authority on to implement the other provisions in that bill. Section 27 is a grant program to law enforcement agencies to hire a post board approved consultant on peace officer policy and training. And finally, Section 28 of Article 10 is Representative Frazier's House File 593, and this would prohibit law enforcement officers from associating or affiliating themselves with white supremacist groups. And it also prohibits the active promotion of international or domestic extremist groups. Mr. Chair, I'll move on to Article 11, which is entitled Corrections and Community Supervision in the House. Section 1 is for Representative Gomez, and it prohibits imposing a bar to medical cannabis participation while a person is on supervised release or probation. The Section 2 is was discussed, well, no, sorry, it wasn't discussed yet, but it authorizes use of inmates' prison ID as a valid secondary form of identification when applying for a state-issued ID. And this is, there's no comparable provision in conference from the Senate, but it is on second reading in the Senate. Section 3 prohibits the Commissioner of Corrections from housing inmates in privately owned jails. This is taken from Representative Winkler's ban on private prisons bill, and there'll be a few additional sections in this article that implement that policy proposal. Section 4 modifies the Department of Corrections annual performance report requirement, and this contains provisions from two separate bills. The bulk of the provisions are from Representative Edelson's EJJ bill, and it requires the commissioner to report on persons sentenced to the custody of the Commissioner of Corrections with EJJ sentences and details what information they need to provide. And it also contains a piece from Representative Johnson's bill on prison audits, security audits, and it requires the commissioner to include information on annual prison audits that are required, or I think it may be biennial prison audits, security audits. Moving on to Section 5 of Article 11. Actually, 5 through 11 are all taken from Representative Long's Corrections Facility Safety Bill. This is House File 1267. And this relates to the inspection and licensing of correctional facilities in the state, and provides much more detailed legislative guidance on what standards should be maintained in those facilities and the authority that the commissioner has in revoking and modifying their licenses based on violations of the standards. I'm going to skip forward to Section 12 of Article 11. This is actually Section 12. Sections 12 and 13 are from Representative Johnson's bill on the security audits that I previously mentioned. And these require a biennial assessment and audit of security practices in state correctional facilities. And it also, Section 13 creates a facilities security audit group underneath the Department of Corrections, and they were tasked with providing standards and review for the agency employees who do conduct the security audits. Moving forward to Section 14, this is a conforming piece from Representative Long's bill, House File 1267. Sections 16 through 18 of Article 11 are taken from Representative Pinto's House File 947. And they relate to juveniles and the search of juveniles, and then disciplinary room time for juveniles in the custody of the Commissioner of Corrections. Sections 19 and 20 are additional pieces from Representative Long's Facility Safety Bill. Section 19 requires all correctional facilities to provide release of information form to individuals when they enter a facility so that they can be properly treated if they become incapacitated. And then Section 20 relates to death review teams and establishes requirements for licensed facilities and how they conduct death investigations that occur within facilities. Sections 21 to 23 are related to the Fugitive Apprehension Unit within the Department of Corrections. And this is an agency proposal that's been around for a couple of years now. And it authorizes the DOC's Fugitive Apprehension Unit to exercise general police powers during the course of official duties, and includes, has language about how the unit interacts with other agencies regarding investigations and arrests and their cooperation in the process. Moving on to section 24 of Article 11. This is expands the duties of the commissioner regarding services to inmates who are soon to be released from incarceration. Mr. Backus discussed some of this yesterday. The House has imposes additional duties beyond what the Senate does in their Article 3, Section 2 on the commissioner to the services that need to provide for reentry of inmates into the community. Section 25 was discussed by Mr. Backus yesterday and relates to the homeless mitigation plan. They are identical except for minor differences about where the report is sent. Section 26 is an additional piece of Representative Johnson's prison security audit bill, and it's a conforming change to implement that proposal. Sections 27 is from Representative Long's facility safety bill, and it updates the Department of Corrections use of force standards, and also establishes a duty to report excessive force similar to the duty we discussed earlier for law enforcement officers. Section 28 is taken from Representative Winkler's private prison ban bill. Section 29 is Chair Mariani's proposal to create an indeterminate sentence release board. Actually, sections 29 and 30 are related to that proposal. Moving on to section 31 of Article 1. This was discussed yesterday by Mr. Backus. They have identical language in the Senate on how pregnant women, the commissioner is able to provide services and special treatment to inmates who are pregnant. Section 32 is from another piece of Representative Elson's EJJ bill that was mentioned earlier. This requires county probation officers to provide the Department of Corrections with data needed to prepare the report on EJJ. Section 33 is from Representative Holland's proposal to limit the grounds for revoking supervised release. This is sometimes referred as a technical violation bill. Section 34 through 37 are from Representative Long's House File 922, and this regulates juvenile detention and specifically use of juvenile restraints, public access to certain juvenile hearings, and alternatives to incarceration for juvenile offenders. Moving on to section 38. This provides that no child may be detained. Actually, 38 and 39 are from House File 947. Section 38 provides that no child may be detained in a secure detention facility after being taken into custody if the person is not over the age of 12. And then section 39 amends the definition of a child in need of protection services to include children who commit a juvenile petty offense or delinquent act before becoming 13 years of age. Current law provides that this child under the age of 10 is the standard. Moving on to section 40 of Article 11. These are additional sections of Representative Holland's technical violations bill, which address offenders being overseen in the CCA, or Community Correction Act counties. Section 41 requires probation agencies in CCA counties to provide the Department of Corrections with data needed to prepare a report on EJJ. This is also part of Representative Edelson's EJJ bill. Section 42 and 43 are additional pieces from Representative Holland's technical violations bill, which again restricts the grounds upon which offenders can have their supervised release or probation revoked. So Section 44 is another piece from Representative Winkler's private prison ban bill. Section 45 is identical to Senate Article 2, Section 12 on alternatives to incarceration. Section 46 is Representative Pinfo's task force on sentencing for aiding and abetting felony murder. This is their tasked with providing proposal and a report to the legislature. Section 47 is a title that is part of Representative Long's facility safety bill, and it's proposed that it would be entitled the Hardell-Sherrill Act. And finally, Section 48 of Article 11 is Representative Becker-Finn's proposal for a working group to study bringing federally recognized Indian tribes into the CCA, or Community Corrections Act, supervision structure. Mr. Chair, that concludes the overview of Article 11. I can move on to Article 12. This is, I'll go briefly on this. This is a House-only provision. It's the Minnesota Rehabilitation and Reinvestment Act, which is an agency proposal that establishes procedures and guidelines to reduce the length of incarceration in state prisons and community supervision for offenders who demonstrate their rehabilitation by completing goals identified in their individualized rehabilitation plan. And again, this is a House-only provision and a proposal brought forward by the Department of Corrections this session. Moving on to Article 13, this is the criminal sexual conduct reform article that Mr. Backus mentioned yesterday. As noted, there's only one difference, and that is a House file. House Section 21 is not contained in the Senate version, and it's a cross-reference related to firearms disqualification if you're convicted of a new offense of sexual extortion. Mr. Chair, that concludes the overview of Articles 10 through 13. I'd ask that you recognize Mr. Johnson to complete the remaining articles.
Very well, thank you, Mr. Debo. Mr. Johnson.
Mr. Chair, members, I'm going to be walking through Article 14 next. Again, I'll be making some references to the side-by-sides. Article 14 is titled Criminal and Sentencing Provisions. Sections 1, 2, 3, 4, and 5 established eligibility for release after 15 years for individuals incarcerated for crimes committed as juveniles when the person has a sentence of life in prison or a sentence that exceeds 15 years. Section 6 appears on page R6 of the article side-by-side, requires the Minnesota Sentencing Guidelines Commission to include a summary and analysis of sentencing adjustments issued under the new prosecutor-initiated sentencing adjustment provision, which will be mentioned later in the article. Sections 7 and 8 make conforming changes related to the eligibility for release of certain juveniles. Sections 9 and 10 establish that the maximum sentence for a gross misdemeanor is 364 days. Section 11, which appears on page R8 of the side-by-side, is the military veterans resentencing provisions. As mentioned yesterday, the Senate has comparable language. There are several technical differences and a few substantive differences. The substantive differences include the fact that the Senate requires that the defendant, prosecutor, and victim all agree to the defendant receiving a stay of adjudication, and the House does not have a similar provision. The House also requires that an offender be in substantial compliance with the terms of probation before receiving the final disposition, while the Senate requires that the offender be in compliance. As a condition of dismissal, the House requires a person to have successfully participated in treatment, while the Senate requires that the person have successfully completed that treatment. In terms of records, the House requires the BCA to maintain a not public record of the discharge and dismissal and establishes when those records are available to law enforcement, prosecution, or corrections authorities. The Senate language requires the court to maintain a public record. The House also has language related to departures from presumptive sentences. It includes either a dispositional or durational departure for any charge that does not require registration if the defendant has engaged in rehabilitative efforts after the offense. The Senate has a similar concept, but they permit a court to enter a dispositional departure if it finds that a person is particularly amenable to probation based on the factors that it must consider when assessing eligibility for the veteran's sentencing. But it excludes several offenses, including those for which predatory registration is required, crimes of violence, gross misdemeanor or felony level domestic violence offenses. Mr. Chair, I'm moving on to sections 12 and 13. Those are on page R14 of the side-by-side, and these are also related to the release of certain juveniles who are serving sentences of 15 years or more. Section 14 amends the definition of violent crime to include sex trafficking in the first degree. The Senate has a similar position in the bill. They use a slightly different effective date. Section 15 establishes a disability impact statement as part of the pre-sentence investigation report. Section 16 requires a neuropsychological evaluation for certain defendants as part of the pre-sentence investigation report. As mentioned yesterday, the Senate carries a study on this topic. Section 17 is a technical change related to changes to the trafficking and prostitution laws. The Senate has a similar position in the bill. Section 18, which is on page R17 of the side-by-side, creates a prosecutor-initiated sentence adjustment procedure. Sections 19 and 20, which begin on page R21, address the crime of assault motivated by bias, and they clarify the types of bias that apply to trigger increased penalties. Sections 21 through 26 increase certain penalties and financial assessments and make conforming changes related to trafficking offenses. Again, these were addressed yesterday, and the Senate has a similar position in the bill. Sections 27 and 28, which begin on page R25 of the side-by-side, are additional pieces related to the release of certain juveniles. Section 29 is another part of the pieces that increase penalties for certain trafficking offenses. Section 30 reorganizes the penalty subdivisions for the crime of identity theft. This is, I believe, identical to Senate File 104, which is currently on general orders. Sections 31 and 32 address the crimes of damage to property motivated by bias and clarify the types of bias that apply to trigger the increased penalties. Section 33 increases penalties for certain trafficking offenses. It establishes a gross misdemeanor for certain trespass offenses that involve trespassing on the grounds of a facility that provides emergency services. The Senate does have this language, and it is identical. Section 34, which is on page R29 of the side-by-side, it clarifies the crime of drive-by shooting. Section 35 addresses the crimes of harassment motivated by bias, and again, it clarifies the types of bias that apply to trigger increased penalties. Sections 36 through 45 address automatic expungement of certain criminal convictions and other law enforcement records. I'm moving on now to section 46. Section 46 is on page R44 of the side-by-side. That section establishes a task force to examine conditions of probation. Task force is also asked to review pre-sentence investigation reports and make recommendations for legislative action to improve the effectiveness of those reports. Section 47 states that the provisions related to expungement may be referred to as the Clean Slate Act. Section 48 directs the Sentencing Guidelines Commission to modify the sex offender grid consistent with the changes in the bill that relate to trafficking offenses. The Senate does carry this position. The language is identical. Section 49, which is on page R46, is a revisor instruction related to reducing the maximum sentence for a gross misdemeanor to 364 days. Section 50 repeals a provision that established a misdemeanor offense for soliciting a prostitute. The Senate has identical language. The final section in Article 14 sets the effective date for provisions relating to sentences for juveniles. Mr. Chair, I'm going to move on to Article 15. Again, I'll be referring to the side-by-side as we go. Article 15 is titled Public Safety. Sections 1 through 9 all address ignition interlock and license reinstatement following a DWI offense. These sections make changes that include expanding the requirement for who must use interlock, requiring interlock companies to cover costs related to damage that is caused by an interlock device, limiting the use of so-called whiskey plates, and eliminating the DWI examination before a person's license is reinstated. Mr. Chair, I'm moving now to Section 10. Sections 10, 13, and 14, which appear on pages R9, R14, and R15, all make similar changes. They direct the Commissioner of Corrections, the Commissioner of Public Safety, and the Minnesota Sentencing Guidelines Commission to perform their duties with a focus on public safety. They also define public safety to include prioritizing human rights. Moving to Section 11, which appears at the bottom of page R10. This section clarifies the predatory offender registration requirements in relation to individuals who commit offenses in other states. The Senate has this provision in Senate File 903, which is on general orders now. Section 12 expands the list of in-home healthcare workers who are entitled to know of the presence of a predatory offender. This section is identical to, I believe it's Senate File 443, which did pass the Senate. And that actually includes sections 12, 13, and 14. Section 15, which is on page R15 of the side-by-side, permits the Commissioner of Public Safety to receive donations and grants. Section 16 is the Hometown Heroes Assistance Program. It involves monetary payment to firefighters who are diagnosed with cancer or heart disease, developing a trauma counseling program for firefighters, and developing training and educational materials to help firefighters reduce the inherent health risks associated with their profession. Section 17 relates to the disbursement of assessments charged to regional hazardous response teams. The Senate has an identical provision in the bill. Section 18, which is on page R17 of the side-by-side, addresses the railroad and pipeline safety account by reinstating the assessment and providing for dispersal of funds. Section 19 establishes an Innovation in Public Safety Coordinator who oversees grants and responses to community violence by working with community organizations to meet local needs. Section 20, which appears on page R24 of the side-by-side, establishes a statewide anti-trafficking investigation coordinator. Section 21 establishes the Office of Missing and Murdered Indigenous Relatives within the Office of Justice Program, which is part of the Department of Public Safety. Section 22 on page R27 of the side-by-side establishes the Minnesota Heals Initiative in the Department of Public Safety to provide grants to community healing networks and establish resources for families after an officer-involved death. It also establishes a statewide critical incident stress management office for first responders. Section 23 and Section 27 direct the BCA to investigate certain criminal sexual conduct cases involving National Guard members. The Senate has identical language in the bill. Section 24 clarifies the distribution of money collected for sales that take place after 1 a.m. The Senate has an identical provision in the bill. Section 25 deletes expired language that established a limit on certain fees. The Senate also has identical language in the bill. Section 26, which appears on page R30, creates a Good Samaritan law for certain individuals who give aid to sexual assault victims. Section 28 directs the Post Board to perform duties with a focus on public safety, and again defines public safety to include prioritizing human rights. Section 29 eliminates the existing statutes of limitations that apply to sex trafficking and first through fourth degree criminal sexual conduct offenses. This language is in the Senate bill. It's identical, except that the effective dates do not address, in the Senate bill, do not address where the cases where the statute of limitations has not yet expired. Section 30 appears on page R34 of the side-by-side. And in fact, sections 30 and 31 both amend session law from 2016 and 2017. They remove references to training, which would become part of the statewide anti-trafficking coordinator's duties under this bill. Section 32 amends the transfer from the alcohol enforcement account. This is identical to Senate File 1354, Section 3, which passed the Senate. Section 33 amends the effective date for training related to the change in the use of force by peace officers language that was adopted by the legislature last summer. It moves that date to September 1st, 2021. This is also identical to language in Senate File 1354, which passed the Senate. Section 34, which is on page R37, eliminates the requirement that the Commissioner of Public Safety certify to the Commissioner of Management and Budget the amounts of permit fees waived under this particular section of law. The Senate has an identical provision in the bill. Section 35 establishes grants to meet the needs of victims by supplying both direct funding to victims and creating programs to meet the unmet needs. Section 36 creates a task force on missing and murdered African American women. And the final section in Article 15, which is on page R42, establishes a study on liability insurance for peace officers. Mr. Chair, I'm going to move to Article 16. Article 16 has no comparable Senate position. I'm going to give a high-level overview of this. It modifies the Child Protection Background Check Act to reflect the most updated federal authorities, to provide the most complete and accurate criminal history information to hiring entities who provide services and support to the elderly and individuals with disabilities. This is in Senate File 1704, which is on second reading now. Mr. Chair, moving to Article 17. This article makes changes to the Minnesota Crime Victims Reimbursement Act. Most of those changes involve replacing the term reparations with the term reimbursement. It also adds guidance as to when a person is ineligible for reimbursement because that person failed to cooperate fully with law enforcement officials, and contributory misconduct, and it also says, that contributory misconduct may not be based on current or past affiliation with any particular group. Mr. Chair, moving now to Article 18, this deals with crime victim notification. This article contains provisions related to notifications given to victims when an offender is released or has a change of status. Changes include requiring prosecutors to notify victims of their rights, accepting letters as written requests for notifications, and addressing offenders who are subject to civil commitment. Mr. Chair, the Senate has no comparable position in the bill. However, this language does appear in Senate File 1611, which is currently on second reading in the Senate. Mr. Chair, I'm moving to the final article now, which is Article 19, Emergency Response and Fire Safety. Sections 1 and Section 8, which appears on page R4, create a waiver process for members of federally recognized tribes to get exemptions from the state building code and state fire code in order to build traditional residential buildings for personal use, meeting houses, and one-room educational buildings. This was in Senate File 1087, which did pass the Senate Labor Committee. Section 2 requires each petroleum refinery operating in Minnesota to maintain or contract for a full-time paid on-site fire department. It also requires refinery fire departments to be properly trained, equipped, and staffed to respond to fires and conduct fire prevention inspections at the refinery. Sections 3 through 7, which begin on page R2, are from House File 2077. They create a firefighter certification board that is tasked with developing and maintaining a program to determine and certify the competency of firefighters. The sections also make related conforming changes. Mr. Chair, sections 9, 11, 13, 14, and 15, which appear on pages R5, R6, and R7, expand the Metropolitan 911 Board to include additional counties, the counties of Chicago, Isanti, and Sherburne. It also renames it to the Metropolitan Emergency Services Board. Section 10, which is on page R5, requires 911 operators to refer calls involving mental health crises to mental health crisis teams when appropriate. Section 12 authorizes 911 fee proceeds to be used to offset the costs of updating and maintaining systems to comply with the next generation IP-based 911 telecommunications. It also directs unspent funds in the 911 fee account to be appropriated for the designated uses of the funds and repeals the decrease of the funds scheduled to take place when the Armor Backbone revenue bonds are paid off. Mr. Chair, I'm moving now on to section 16. This is on page R8 of the side-by-side. It establishes a 911 working group to recommend standards for training, certification, continuing education, and funding for 911 telecommunicators and services. The Senate has an identical provision in Article 2, Section 15, except that they do not include the 3 non-supervisory 911 telecommunicator members and do not include a Minnesota Ambulance Association member. The House language includes those additional members. And the House language does not include or require that the working group look into incident response command structure. Excuse me, the Senate language does not. It's required in the House language. Section 17, which is on page R10, is the final section. It requires 911 operators to refer calls involving mental health crises to mental health crisis teams. It requires that that provision be known as Travis's Law. Mr. Chair, we were aiming for an hour, and I think we hit it pretty much to the minute. That concludes the walkthrough of the House bill.
Very well, thank you.
Chairman Mariani, I believe we may have lost you, or maybe I did. I don't know if anyone else did.
I did as well.
Why don't we see if he can hook up with us again? We can pause for now.
Yeah, I just admitted him again. I think he must have got kicked out.
My apologies.
There he is.
My goodness, I disappeared on you, Mr. Chair.
That's all right. I knew you'd come back to us.
Sooner or later, that's right. Yeah, I actually plugged in my laptop, but I only half plugged it in. And as fate would have it, just as Mr. Johnson was wrapping up, I looked up and it showed like 1% power. And I thought, oh goodness, I just caught it, and then boom, it went out. So my apologies. I'm on my cell phone, but I'll try to get back on the hopefully a better sound system. Yeah, thank you, Mr. Johnson and Ms. Mullen and Mr. Diebel. Boy, you must have just rehearsed that, because that pretty much was an hour as we had planned or wanted it to be. So members, what I want to do next then is to hear very limited testimony from 6 individuals, our 3 commissioners, as well as several others. I'll introduce them as we go along. And what I want to do is just to hear concise perspective on the importance of broadly acting now on many of these provisions, including sharing any urgency for such action and how provisions that they wish to highlight align helpfully with the work of local and state government as well as the work of citizen groups to make Minnesota safer and better. And, members, what I'm trying to do basically is just to demonstrate that there is a real good logic and a good alignment and consistency with a number of initiatives that have been underway in our state for a while. Some of you who have served in these committees in the past know that some of the provisions we've seen in one form or the other in the past, and we've done some steady vetting of that. Some of them we even had gotten to accord to, but because of all sorts of political dynamics beyond the control of my Senate counterpart and myself, we were not able to finalize that. And so I just want to be able to give a good, broad relevancy scope, for the committee members. And by the way, for the public, if you could also be sure There, Lance, I think we're hearing your music. It sounds wonderful. For the general public, if you can go to the website for the hearing, and you'll see quite an impressive list of organizations and institutions across the state who are chiming in on a number of the provisions, some of them in common with the Senate, some standing alone in the House bill. And, these range from the Association of Metropolitan Counties, who, or rather the AMC, who are commenting on the emergency management grants, the NAACP and the Department of Human Rights, both their sheriffs and their chiefs in support of the U visa provisions, Hennepin County and the no-knock warrant changes and regulations, legal aid on the alternatives to incarceration and clean slate. So there is a very mature body of work that's being presented here that literally dozens and dozens and dozens of hands and minds have been engaged in. But at this point, I want to begin by calling forward our Commissioner of Corrections, Commissioner Paul Schnell, interested in hearing very quickly on prison safety reform, early release, and juvenile justice changes in particular.
Thank you, Mr. Chair, and both chairs and members. I really appreciate the opportunity to provide a brief overview of the critical nature of the policy provisions that we think are important at this time. We believe strongly, and I want to just say that today I want to talk about these high-level items, and tomorrow Chair Limmer has invited me to speak directly to the agency's budget. Chairs and members, let there be no doubt that the funding for our agency's budget is important. It keeps the lights on. It allows us to maintain the delivery of critical services provided by the agency. But I can't understate how important it is that our state implemented policies now that are smart, modern, and reflect the needs of our time and the people we serve. Now is the time that we should confront and address the profound racial disparities in our criminal justice system that have impact, whether that occurs through justice by geography, or because of limited access to services, or most significantly through the disparate treatment and outcomes for BIPOC people in our state. As an agency, we're hearing loud and clear the demand for new approaches and smart reforms that promote racial equity, restoration from harm, and the need for growing trust in our communities, which, when combined together, actually strengthen public safety. I want to mention very quickly, three policies. First, I want to talk about enhancing safety in licensed correctional facilities across our state. Chair members, I've said this before, we face a crisis in our state's responsibility to ensure the health and safety of those incarcerated in local correctional facilities across Minnesota. I want to highlight the fact that it's been 115 years since the Minnesota legislature took a substantive look at the use of force authority granted to those in correctional facilities. It has been nearly a half a century since there was any substantive change in the statutes governing our responsibility to ensure oversight and regulations of jails and correctional facilities across our state. For those of you who may not have had the time to follow it, the Cruel and Unusual series on KARE 11 laid bare the incredibly disturbing and harrowing events that have taken place in jails across Minnesota and the gaps in our ability to respond to and address issues that have existed in those jails. We've seen far too many deaths in custody not to act. For example, nationally, suicides account for about 31% of jail deaths. But in Minnesota, we have double the national average, where suicides account for 60% of deaths in our jails. As mentioned, the DOC's licensing and inspection framework in statute is nearly 50 years old. It's confusing, vague, and provides no clear accountability measures. And the use of force statute, as I said, has not changed since 1905. And to say it plainly, there are major deficiencies in the statutory policy, which make the difference between what a law enforcement officer would do on one side of the fence around a prison, as for instance, and what a correctional officer would do on the other side of the fence inside a correctional facility. And I think this disparity of policy is confusing and needs to be updated. I would also highlight that we worked really closely with the Sheriff's Association, are so grateful to them in the development of the bill we brought forward. And it's notable that the House Public Safety Committee passed the provision unanimously. Chair and members, we cannot go through the session without taking action on this policy, I believe. While we do not have, while we do not oftentimes think of the deaths in correctional facilities the same way we do other law enforcement involved deaths, I can tell you that I spent many hours talking with parents and family members of those who died in custody, often without being provided basic care. And they feel, and rightly feel, this clear sense that it is our state's obligation to act. I want to highlight the policy provision that was mentioned in the overview of the bill, the Minnesota Rehabilitation and Reinvestment Act. And it's an initiative that really reflects SMART policies. SMART in that it promotes public safety outcomes and incentivizes rehabilitation, which reduces risk of reoffending and increases the likelihood of successful reentry in our communities, what we all want. And I would just say that the Minnesota legislature has created statutory authorities for programs that ultimately incentivize people doing well. The Challenge Incarceration Program, or CIP, is an earned, and I emphasis on the word earned, incentive program, which has reduced significant reductions in recidivism when compared with other programs. The MRRA provision, this Minnesota Rehabilitation and Reinvestment Act, expands and earned incentive opportunities focused on rehabilitation. It's been done, and similar reforms have happened in about 38 other states. And it really does so by focusing not on having people in time, how much time they spend in prison, but how that time is spent. The positive impact on reinvestment provisions in this proposal cannot be ignored. While we can't book this revenue today, the measure gives individuals the tools to leave prison and never return, thereby increasing community safety with actual savings that would be placed in a special revenue fund and biennially reinvested in 4 areas. First, victim services. Second, correctional supervision and support. Third, addressing gap services that exist across our state, particularly in greater Minnesota. And the fourth, and something that you rarely hear in legislative policy, that 25% gets returned to the state's general fund. We believe that when fully implemented, MRRA will make our state safer, focus our attention, create the opportunity for us to focus attention on those who need services and supervision most, those who represent the greatest risk. And we believe that we can save $10 million each year, $20 million biannually, which means that the legislature could have that $5 million to fund other important measures, much like, for instance, the tails on the criminal sexual conduct statute reforms. Without this funding and authority, Minnesota will continue to use a one-size-fits-all approach. We thereby waste state resources, treating everyone the same, whether they're invested in their transformation and community safety or not. And this simply doesn't make sense. And finally, chairs and members, I have to say that today it's a travesty that in Minnesota, we do not have access to statewide data or the ability to make informed decisions about how young people, youth, interact with the child welfare and justice systems. I think of the quote, "The children who need love most will often ask for it in the most unloving ways." We know this. We know that we have young people that have all kinds of adverse childhood experiences. And when children are seen as threats, ultimately, we don't provide them with adequate supports and services, which ultimately further traumatizes them and results in them living lives that ultimately compound the challenges they face and really make all of us less safe. But first and foremost, them. The reform provisions in the juvenile justice data central repository do just that. It helps us to make good decisions and guide policy going forward. It's also time for us to prohibit the use of solitary confinement for youth, as it leads to permanent harm to children's physical and psychological growth, their social well-being. Numerous organizations nationally have supported ending the use of solitary confinement, including the Council of Juvenile Justice Administrators. The federal government has banned the use of solitary confinement for youth since 2016, and there has been no impact on the safety of federal correctional facilities since that prohibition was put in place. Almost a dozen other states have followed suit. It's time that we prohibit the use of strip searches of children as a practice that's invasive, degrading, and traumatizing. There are less intrusive approaches that can accomplish the same safety goals. There are facilities in Minnesota that have already implemented this as a best practice and have changed their policies and practices to align with these proposals. There are categories of other proposals intended to align our laws and require practices that take information about how brain development affects young people and what that means by way of how we treat young people in the system, including thinking about risk assessments and ending indiscriminate use of shackling for juveniles, explicitly authorizing alternatives to arrest, using the least restrictive environment, eliminating public hearings and records for 16 and 17-year-olds in delinquency records. And importantly, raising the age of delinquency to 13 and limiting the age of detention admission to children 13 or older. We must continue to address and minimize the traumas that young people face in the system. The criminal justice system and youth justice system should be one that's service focused. Mr. Chair and members, I want to thank you for permitting me the time to speak to this today. I look forward to working with the conference committee as we go through this process to talk about how it is we can go forward together to ultimately live out the DOC's mission of transforming lives for a safer Minnesota. And Mr. Chair, I would stand for any questions when the chair feels it's appropriate. Thank you for the time.
Very well. Thank you, Commissioner. Thank you for your fine work. And, you know, it's been 2 years since we heard the OLA report on prison safety. I know the Senate also held a hearing on that. And so it's a good testament to good government in the state of Minnesota that our Department of Corrections can take that kind of work and get into it, roll up their sleeves and come back with some pretty powerful and relevant proposals. Similarly on the other 3 proposals as well. Yes, if you can stick around for questions, I would greatly appreciate that. Next, I'd like to call forward our Commissioner of Public Safety, John Harrington. Welcome, Commissioner.
Good afternoon, Chair Mariani, members of the committee. For the record, my name is John Harrington. I'm the Commissioner of the Department of Public Safety. And I want you to know that the Department of Public Safety is acutely aware of the public safety crisis that Minnesota finds itself in. We are in the midst of, unfortunately, record numbers of homicides, fatal crashes, violence against women, and fires, all occurring at the same time that we are having a robust conversation about what should policing look like. I want you to know that the Department of Public Safety has leaned into this conversation 2 years ago when we started the Deadly Force Encounters Working Group. But beyond that, the conversation we've been having around Minnesota Heals and working with community to find real community-based solutions to community violence and to violence among community members. We have worked on the Missing and Murdered Indigenous Women program, which I think is just one small part of violence against women, but a very significant research effort that we have already started taking note of and have used as a basis for doing human trafficking investigations in greater Minnesota. We are especially attuned to the issue of juvenile justice reform and really do want to highlight the fact that we believe that it is as important for us to do right by juveniles before they come into the system, and in fact, prevent them from coming into the system, as it is important for us to do right by them once they are in the system and are being held accountable. With my 5 minutes, I still have a couple of points that I would like to make. One is around the issue we've been talking about around compliance review. And I need to note that the compliance review conversation has primarily been around the Minnesota Post Board, the Peace Officer Standards and Training Board, which is not a function of the Department of Public Safety. But as part of the Deadly Force Encounters Working Group, we looked at that. We brought in then the executive director of the Post Board to testify to that group because we recognized that compliance review and continued activity around licensure was an important component of holding police officers and police departments accountable as we were moving through a process to try and find out how could we reduce the number of deadly force encounters. That model has been expanded, and now we have that conversation with a variety of community groups around this, including Violence Free and MNCASA, as we've talked about, with the BCA now taking on more responsibility for doing investigations, for example, of sexual assault allegations against National Guard members, and doing those investigations where they involve police officers or peace officers. I want to note that I'm very thankful that the governor included the 4 FTEs in his budget proposal. I think that is a really important start to this process. We have to understand that to simply pass policy without providing the resources to implement that policy properly just breeds both a distrust of the system. People ask, well, if you pass that law, why isn't it being enforced, and why aren't good things happening already? But it also it increases the poor performance. It becomes routine, and people begin to expect that, well, I'm not going to get an answer to that question. And really what it is oftentimes simply a lack of staff to do the work that we all want to do. We continue to believe that a centennial review system is also a very important approach to looking at especially issues around deadly force encounters. We recognize that you're not going to do a centennial review for every use of force incident that occurs, but for those major incidents, and whenever a public servant takes the life of a citizen, I think those are moments where a centennial review of an outside group looking at what were the circumstances is an important element to us improving our performance and improving and reducing those deadly force encounters. Another piece of holding people accountable and reducing deadly force encounters is in body-worn cameras. It's been a topic that we recommended as part of the DFE recommendations. And while there were concerns expressed during those hearings about local control and local authority over whether body-worn cameras should be employed, I still really strongly recommend that as a state, we need to have body-worn cameras on every officer in the state of Minnesota. I really do fundamentally believe that just as a young rookie cop in St. Paul, I put on a bulletproof vest every day before I went out the door. every rookie cop that I send out the door should have a body-worn camera on it because it protects the officer and it protects the citizens both. The studies have shown that at least 11 studies have shown that when you have officers wearing body-worn cameras, you see a reduction in the number of use of force incidents. And 20 different studies have showed that when you have officers wearing body-worn cameras, complaints about officer misconduct go away or drop down substantially. I mentioned the juvenile justice piece, and I think it's an important piece for us because it's making an investment in creating something that will in fact change the dynamics of how the state sees young people. Our request speaks to not only to our federal jurisdiction, which is given to the Department of Public Safety, but it also speaks to the needs of young people that we're seeing all too often today who do not have the resources. And part of that is that we need to do a better job of coordinating what is oftentimes a patchwork of nonprofit, educational, churches, schools, and families who are trying to do the best they can for young people, but young people are slipping through the cracks. And I think we need to do a much better job on that. Last, I will speak to a more recent issue that has come up, which is traffic stop legislation. The House has started a conversation. I would say that's where this conversation started. And we recognize that the case of Dante Wright, what started as a traffic stop ended in a tragedy. But we're also cognizant that in order for us to have statewide rules about traffic safety, that we need to have a broader conversation about that. And we need to work together to come up with good policy that can be in fact in place statewide. You should not have to wonder if you're driving from Duluth to Worthington, whether or not the rules of the road change for you by jurisdiction. I think we have to make sure that what we're doing is consistent and can be consistently enforced and employed statewide. It is not lost on me because of the State Patrol's duties in that area that we have had this far 114 Minnesotans who've lost their lives on state roads. That's 25 more than we had at the same time last year. The fatal crashes are continuing. Speed, distracted driving, intoxication, all of those issues continue to plague Minnesota roads. And we are seeing young families, we're seeing young people and old people pay the ultimate cost of that in losing their lives by senseless crashes. We believe that traffic safety law and traffic law has to have as a goal the reduction of traffic fatalities and traffic injuries at the same time that it has to have a goal of a system of procedurally just rules that make good sense to everybody, that people understand and that they can live with and can abide by. I really do appreciate your time today. The Department of Public Safety is in so many places in your bill that I'll be absolutely delighted to talk more about our budgets and things tomorrow. But I'm also happy to stay on and answer any questions that you may have today.
Thank you, Commissioner. I greatly appreciate it. You know, you began your presentation pretty much in some ways echoing some of the things that Chair Limmer shared yesterday in terms of disturbing recent dynamics around violent crime in particular. And so, to have a public safety department that is aware and constantly adjusting and looking at both policy and practice and bringing that to us, very deliberately and carefully is, the best way in which the legislature and the executive branch can work together to address these issues. So thank you. Thank you for your observations. And yes, if you can stick around for a bit, hopefully there'll be some questions and some comments that perhaps will bring you into further conversation. With that, I'd like to call forward the Commissioner of the Department of Human Rights, Rebecca Lucetto.
Hi, good afternoon, Chair Mariani, Chair Limmer, Chair Becker-Finn, Chair Matthews, and all the members of the Public Safety and Judiciary Conference Committee. Yep, my name is Rebecca Lucetto, and I am the Commissioner for the Minnesota Department of Human Rights. That's Minnesota's very own Civil Rights Enforcement Office. Now, I was invited by Chair Limmer to talk about the budget tomorrow, and I'm very much looking forward to doing so in detail. Today, I've been invited to talk specifically about policy provisions in this bill, and I'm excited to do so. I believe that we're in a pretty unique moment in history and that we're all called to move both budget and policy pieces that are important to Minnesota. We cannot wait. So I'd like to start by first talking about the Preventing Pay Discrimination Act. Now, this is in Article 6, Section 6 of the House Omnibus bill. Now, the goal of the Preventing Pay Discrimination Act is to help close the pay gap in Minnesota. The policy does this by protecting a job applicant from having to disclose their pay history when they are applying for a job or negotiating their salary. This means that an employer cannot require or ask that a job applicant disclose their pay history when they are applying for a job or trying to negotiate their salary. So after all the work we have done to come back after a brutal recession and a housing crisis, the pay gap between men and women still hasn't narrowed. And COVID-19 is exacerbating this problem. More than 575,000 Minnesotan women have filed for unemployment insurance since the pandemic started. And women are more heavily concentrated in the hardest hit industries like accommodation and food services and other services. This is particularly true for women of color. So women are more at risk for long-term unemployment during the current pandemic recession. So we need to do more, and especially because of the pandemic, we simply cannot wait. Numerous state and national research reports show that women are persistently paid less than men with similar experiences, qualifications, and seniority for the same job. White women on average make 78 cents for every dollar a man makes in Minnesota. And if we look at pay data for women of color and Indigenous women, it's even worse. So for every dollar a man makes, a Black woman makes 61 cents. For Hmong women in our community, that's 55 cents to the dollar. Somali women, 44 cents, and Indigenous and Latina women, that's 54 cents. So importantly, the policy works. It has been implemented in 18 states, and the 18 states that have eliminated the pay history question has seen an 8% increase in pay for all women and a 13% increase in pay for Black workers once they implemented this policy. So ending the pay history question is one critical step that helps closes the pay gap. We have had very productive conversations with members of the business community. It's been a collaborative approach, and we've taken the thoughtful suggestions made by the business community and amended it along the way. So we strongly encourage the conference committee to adopt this policy proposal in its final omnibus bill. It's a simple step. It has strong bipartisan support throughout the House committee process and also on the House floor. This is a long-standing historic problem exacerbated by COVID, and we know that this works. So making this change now means that we are meeting this moment by taking the steps to address both gender and racial pay gaps. I'd also like to discuss the bias and hate-motivated incidents, the policy that's laid out in Article 6, Section 4. Again, this is an important time in Minnesota. We've heard and witnessed stories of Asian Americans and Pacific Islanders who have experienced some appalling acts of violence and hate, particularly over the last year. Some of the saddest ones for me personally are the ones that are reported to our office around really young kids, young non-Asian children telling Asian kids to go back to China, while even hitting and kicking the Asian kids. Last week during Ramadan, the Moorhead Fargo Islamic Community Center was vandalized. Before morning prayers, the imam found racial slurs and a swastika painted in red spray paint on the walls and doors of this sacred community center. So we're in a critical juncture where we must and can choose to do better. And as we can see, Minnesota can't wait. That's why we applaud all efforts to meet this moment and include critical policy changes to improve the state's ability to have better, robust data around this. So the proposal in Article 6, Section 4 begins to address this. Now, I want to be really clear on this because I know there were some questions about this. This bill does not add any protected classes. It instead provides language for our department to work with community-based organizations on data collections and reporting on protected classes that already exist under law. It also creates a collaborative relationship between our department and the Post Board. And that way we can help inform training policies and procedures around incidents motivated by bias or hate. So for some time, for a long time, community members and community groups have expressed how the current reporting systems fail to capture many incidents motivated by bias and hate across the state. So we need more robust data. With that more robust data, the state, you legislators, can better understand, address, and support victims of hate and bias motivated incidents. And that's why we're asking the conference committee to take action on this now. There is also a provision that I'll talk about around strengthening the source of income protections in housing. This is Article 6, Sections 7 through 9. Now, all Minnesotans should be able to access housing without experiencing discrimination. So this policy specifically amends the Minnesota Human Rights Act to clarify that no one can be denied housing only because they access rental assistance. And I want to be clear about this. This proposal does not require a landlord to accept an applicant just because they have a voucher. Instead, it simply says that the applicant must be considered for housing without taking into account if they will be paying a portion of their rent with the housing voucher itself. The Center for Budget and Policy Priorities estimates that 77% of Minnesota's housing vouchers go to families with children. So this means that 42,000 Minnesota children can be positively impacted by this policy today. And that's why we can't wait to make this change. There are countless benefits when children and families have safe, stable, and affordable housing. You all know it. So as you continue to develop the final omnibus bill, I encourage you all to include this in the final bill because children and families cannot wait. I do want to note that both the source of income protections and the hate crimes bias policy that I just mentioned do have budgetary impacts to our department. This is something that Commissioner Harrington noted as well, the importance of both policy and budget. Both of these policies are good examples of how civil rights require intentionality with both policy and budget. It is important to have strong policy that strengthens civil rights and prevents discrimination, but it is equally important to fund the work. That is why we encourage both the House and the Senate to adopt the governor's budget proposals for our department on these. Finally, I would be remiss if I didn't mention two other policies that both received unanimous bipartisan support in the House Judiciary Committee. The interactive process for disability policy found in Section 5 of Article 6 updates the Minnesota Human Rights Act to clarify and provide expectations around reasonable accommodations in the workplace. This is a non-controversial policy that helps clarify the importance of having a collaborative conversation between an employer and an employee to see if there is any reasonable accommodations that exist for someone with a qualified disability. Have the conversation. It's just an important change. And it's an easy change. It received unanimous support in the House Judiciary Committee and has bipartisan authorship in the Senate as well. We also, I also just want to take a second to point out our technical bill, which is ultimately about making the department operations more user-friendly, consistent, efficient, and effective. This is found in sections 1, 3, 10 through 14, 17, 18, 21, and 22 of Article 6. These non-controversial provisions make changes recommended by the OLA, such as providing additional time for employers and landlords to respond to a charge of discrimination. It brings our statute into the 21st century by allowing our department to send and receive documents electronically for parties, if they choose. And it also makes technical changes to our equity and inclusion for state contracting. Again, these are non-controversial technical changes and have unanimous bipartisan support in the House Judiciary Committee. So given Chair Mariani's request to focus on policy today, I think it's fitting to close by highlighting that this May, and I can't believe it's already May, but this May is the 54th anniversary of the Minnesota Human Rights Act. 54 years ago this month, legislators came together, Republicans and Democrats, around civil rights. And then Republican Governor Harold Levander signed the Minnesota Human Rights Act into law. Over the past 54 years, the legislature has intentionally made changes to the civil rights law to help address and prevent discrimination based on race, disability, sex, age, religion, and other protected classes. The goal of those legislators originally 54 years ago was to build a more equitable and inclusive state. And that's what I urge you to do again here today. Meet the moment we're in so that all Minnesotans can live lives of dignity, free from discrimination. Thank you so much. And I'm, of course, happy to stick around to answer any questions. Have a good day.
Very well. Thank you, Commissioner Lucetto, and thank you for reminding us of the moment that we are in. And I think of it as a good opportunity for us to keep building a strong, safer Minnesota. And I know that as you and the other commissioners have shared so far, that resourcing our vital institutions, such as your department, is absolutely critical. And it must be done in order to really maximize the return on it by constantly looking at policy and aligning it with those resources, and vice versa, as Commissioner Harrington talked about earlier, where we might have real good policies, but if we're under resourcing them, we create a pretty negative psychology among the citizenry. So yes, thank you. If you can stick around, we're going to push on. We have Chief Jungman with the Minnesota Fire. AC. You're going to have to tell us the full name of the association, but it's awfully good to see you. Thank you for being with us here today. One of the things, frankly, that I've not felt particularly good about over the last couple of years is how much we've underpaid attention to the incredible profession that you're a part of, and the broad community of people who are firefighters in our state who give so much. And so I'm really glad that we're able to focus much more attention this year in our bill. So welcome to the committee and to the conference committee, and look forward to hearing from you.
Thank you, Mr. Chair. Good afternoon, Mr. Chair and chairs and committee members. My name is BJ Jungman. I'm the fire chief for the city of Burnsville. I would like to thank you for crafting the Public Safety Omnibus bill and allowing me to testify during the process. I am here today on behalf of the Minnesota Fire Association Coalition. We are an organization comprised of 4 statewide fire associations: the Minnesota Fire Chiefs Association, the Minnesota Fire Department Association, the Minnesota Fire Marshals Association, and the Minnesota chapter of the International Association of Arson Investigators. I would like to start by thanking both public safety chairs and all of the committee members, including many important fire service provisions in the Public Safety Omnibus bill. These provisions are important to the Minnesota Fire Service's mission. Thank you for keeping the fire safety account intact. This account funds the State Fire Marshal's Office, the Board of Firefighter Training and Education, the statewide response teams such as the hazmat teams, air rescue, and Task Force 1, which does urban search and rescue, and many other worthwhile statewide projects that improve the fire service's ability to serve the Minnesota citizens. There are many worthwhile projects that far exceed the funding that is available, and we appreciate you keeping that funding intact. I know you're probably sick of me talking to all of you about it, but it is a vital funding source for the Minnesota State Fire Service. We also support the Hometown Heroes Act that helps with the education and mitigation of 3 very important health topics to firefighters: emotional wellness, cancer prevention, and heart health. We also appreciate your support in enabling legislation to move this Minnesota State Fire Service Certification Board under the Department of Public Safety and State Fire Marshal's Office. This is a no-cost solution to the state, as it is a fee for service. This move is supported by all 5 statewide fire service organizations. Certification is voluntary. Currently, the certification board is a nonprofit organization, and the current executive director plans to retire at the end of their contract. An RFP process was conducted, and the State Fire Marshal's Office was the only respondent. The current board voted overwhelmingly to move the certification function to the State Fire Marshal's Office. The transition is time sensitive. It will also keep the oversight board that is made up of the Minnesota Fire Service, of both Greater Minnesota and the Metropolitan Fire Services. This transition will get licensing, which is required for career firefighters, and certification, which is voluntary, under one roof, which will be a streamlined process for the Minnesota Fire Service and make things easier. MINFAC also supports the creation of the 911 telecommunicators work group to evaluate creating standards for the 911 telecommunicators. This is a vital piece of the public safety services that we provide. I would like to thank the chairs and all the committee members for your support, and I'd be happy to stand for any questions.
Thank you, Chief Jungman, for being with us here today, but also for keeping us constantly informed on issues in your profession and in our communities. And it's kind of hard to talk about it as a profession because, you know, it's like talking about community life. You have so many members that, you know, they're volunteers. They're all over the state. They love what they do, and they're true public servants in the best meaning of the word. And so thank you for constantly keeping us in touch with them. Next, members, we're going to hear from Peg Larson. Some folks may know this, but Peg and I actually served together on the same committee, and we did some really good work together a few years ago. But Peg is here to speak on issues of sexual assault, victim survivors, and I believe a bit also on the working group recommendations. So Peg Larson, welcome.
Yeah, but thank you very much, Mr. Chair. Good afternoon, Mr. Chair and members of the conference committee. My name is Peg Larson, and I've lobbied for Minnesota Coalition Against Sexual Assault for approximately 15 years. I'm very happy to be here with you today to emphasize all of the ways this bill does the critical work of improving our Minnesota system response to victims of sexual assault. We are very pleased that House File 707 and Senate File 1683 have been included in both omnibus bills. I would be remiss if I did not mention that the Criminal Sexual Assault Working Group is part of Senator Ralph's legacy. I also want to thank Representatives Mueller, Mariani, Becker-Finn, and Senator Senjum, Limmer, and Latz for their work to move these critical reforms forward. The Criminal Sexual Conduct Statute Reform Group was created by the legislature in 2019. Nearly 80 members worked for over a year and a half to develop the legislative recommendations found in this section. The membership included prosecutors, defense lawyers, survivors, crime victim coalitions, and representatives from many aspects of the Minnesota criminal justice system. The results of this work are included in both bills. There are many items in the bills that we support. One important item is the funding request for OJP. Many advocates have reported that since the pandemic began, survivors' needs and situations have become more complex. Funding for the direct needs of survivors is woefully inadequate, particularly in this time of COVID. This funding would help improve that situation and other things that we are thankful for. We are thankful for the crime of extortion language and the voluntary intoxication fixes. MnCASA also supports the Missing and Murdered Indigenous Women's Relatives Office and the Missing and Murdered African Women's Task Force. This is important work that needs to be done in Minnesota. And another item that MnCASA supports is the youth visa section of the bill. This brings to light the great need for a timely response to these requests. This section does not mandate an approval. It simply requires a timely response. And finally, we thank you for eliminating the statute of limitations for criminal sexual conduct. This has been a survivor-led MnCASA-supported initiative in front of the legislature for a number of years. In fact, I think, Mr. Chair, it was there when you and I served together.
Indeed.
You have heard the voices of victims throughout this legislative session. We thank them for their courage to speak up and help us all understand about the needs of survivors across every county in the state of Minnesota. You may not know you know someone, but you do. Thank you for your attention and action on these critical issues, and I will stay for questions.
Very well. Always good to see you, Peg. Welcome.
You too.
Thank you for being here. And thank you for your work with MnCASA. And then finally, we have Jason Flores from Americans for Prosperity.
Good afternoon. Thank you, Mr. Chair, members of the committee. My name is Jason Flores. I'm the State Director for Americans for Prosperity here in Minnesota. Thank you so much for the opportunity to be here today and share some thoughts on various provisions within the omnibus bills that you have before you. We too believe there is a strong sense of urgency about moving forward this session with important public safety and criminal justice reforms that have bipartisan support. Despite the divide between these two bills and the divide in public rhetoric, there are several initiatives that enjoy support not only from a wide range of coalition groups, but also bipartisan support among legislators, both here in Minnesota and across the nation. And they are supported not only by activists working on criminal justice issues, but they've also earned the approval of law enforcement officials because of the common sense approach to increasing public safety and focusing resources and attention where they're needed most. As was previously noted, these are issues that have been discussed and vetted over years of work at the legislature and in the community, and the time to implement them is now. At Americans for Prosperity, we believe an effective criminal justice system protects people and preserves public safety, respects human dignity, and removes barriers to opportunity for people seeking to earn a second chance. A core function of our justice system has to be imposing accountability, but we should seek to incentivize rather than inhibit the success of those who have been held accountable through incarceration and are willing to work toward that second chance. Now, Minnesota has one of the lowest recidivism rates in the country, but still almost 40% of those exiting our state prisons will be convicted of another felony in just 3 years. This rate is relatively consistent over the course of the last decade. Now is the time to do more to ensure public safety across Minnesota. We cannot keep doing the same thing and expect a different result. I want to start by thanking Commissioner Schnell for the work his department is proposing to do through the Rehabilitation and Reinvestment Act, which will improve second chances for those currently in our state's justice system. And I think it builds on the recent bipartisan passage of the First Step Act federally as well. It will help foster a more constructive culture in our state prison and community supervision programs by expanding on evidence-based programming in treatment and training, by individualizing and customizing programming, by allowing participants to earn release credits, and by incentivizing compliance within community supervision once they are released from a facility. Now, notable in a budget omnibus bill, the proposal doesn't require any upfront investment and actually reinvest 75% of the savings back into further improving department programming. Truthfully, it's the kind of approach that we'd like to see more of across state government. Also related to reentry, the provisions originally heard in House File 553 and supported in the Senate would assist those released from a state facility in obtaining a Social Security card, birth certificate, a driver's license or other identification cards, and necessary bridge medication, all vital elements in securing housing and employment upon release. We already see more than 10% of those coming in and out of prisons experiencing some kind of homelessness. So this bill will help that and will also establish individualized homelessness mitigation plans and increase state reporting on homelessness so we can help people get back into the community and avoid a return to the correction system. On another note related to the courts, fines and fees have a very significant impact on individuals that already have a limited or no financial ability to pay. And lack of payment often results in other adverse actions against those individuals that in turn lead to a cascading set of unintended consequences. We often talk about these provisions and these fees in terms of revenue raised, but there's other costs that we need to consider as well. For example, the amount of time that law enforcement spends interacting with individuals on outstanding fines or fees that are still hanging over the top of them, it could be better targeted at more critical public safety needs. Now, this is one reform that's often mentioned in conjunction with driver's license suspension reform. That's an idea that's received support from members of this committee and in both the House and the Senate. And though it's traveling separately in the Transportation Omnibus bill, I do want to highlight it here because it's that same kind of bipartisan approach that eliminates barriers that government puts in place. And it's one of those barriers that actually makes it harder to get those original debts paid and pushes people into breaking law because they still need to get to work. We shouldn't divert resources by engaging law enforcement in debt collection, and we should keep them focused on public safety. Now, finally, we've worked for years to make reforms to asset forfeiture laws and fully support the compromise language that's included in the House bill in front of you. While it doesn't fully eliminate civil forfeiture processes, this legislation is a strong step forward that will protect Minnesotans' property and due process rights and keep the vast majority of claimants from ever being forced into an onerous and convoluted civil system in the first place. Because so many forfeitures are small dollar amounts, the massive procedural barriers put in place quickly make the choice to pursue any litigation a more expensive option than actually the value of the property that you lost in the first place. Many claimants, including those likely to prevail and those never even charged with the crime, they just make the economic choice to walk away. Under current law, that's about 95% of people that lose their property through administrative process that don't even attempt a recovery. In conclusion, Mr. Chair, by enacting these bipartisan policy changes, Minnesota can move closer to respecting human dignity, reducing the recidivism rates, and thus improving public safety, focusing law enforcement resources on critical needs, and removing barriers that prevent individuals from earning a true second chance. I'd refer you to the letter I sent prior to committee today for a little more detailed information on each of these items. And thank you again for your time and attention to these issues and the opportunity to share our members' thoughts here with you today.
Thank you, Mr. Flores. Thank you for your work over the course of the years here. And I would add to your list of benefits, but you did reference it earlier, is that it's also economically smart in terms of, what we spend, not as efficiently and as effectively, currently. And so, constantly bettering our practices is also a good way to protect our state resources, our tax dollars, et cetera. So thank you.
Absolutely.
All right, we're going to open up to questions. I'll start with Senator Ingebrigtsen. Senator.
Thank you, Mr. Chair, and thank all the commissioners for their reports here, as well as the staff going through the bill. It's a very large bill, I might say. But if I could just somehow back up to, I believe it's Article 10. There's and somebody can answer the question. Annual complaints department and list of trainers list. I think it's pertaining to the post board and giving them more functions. Who do these reports go to? That'd be my first question. Then I'd like to answer or ask a couple more, Mr. Chair.
Yes, please. Do you have a reference of a section in Article 10?
I think it's section Article 10, section 13 and 14 is my notes right in there. 14 through 16, I believe.
Let me catch up. So this is in reference to House File 1374.
Yeah, I apologize, Mr. Chair. I was taking notes as I went along here. I couldn't keep up with the page flipping, so.
Yeah, well, I was trying to catch up as well.
Yeah.
Not to worry. And while I get myself together, I'll see if maybe there's a technical answer in terms of answering that from our staff. But the question is, I'm sorry, Senator Ingebrigtsen, the data collected going to?
Yeah, it's called the Annual Complaints Department, and a list of trainers. That's 14, and number 16 was list of trainers. I'm assuming that's post board. Who would have access to that? And I guess I'm just wondering, do they have such a list now, or it's been a while since I've been involved with the post board. Maybe that's where it is. I'm not sure exactly where it comes from.
Yeah, I think it is the post board, and part of this could also be the post board's agency bill. My understanding is that they indeed do have a list of trainers. One of the things that I've discussed with them over the years, and even Senator Limmer and I had this very, very brief conversation a couple of years ago, was to be able to have some kind of way of assessing the effectiveness of the training and therefore by extension the trainers. In my conversations with the post board, there's a real strong interest that they've expressed in making sure that our state resources being used are in fact being effective, I do think they do, like, a periodic assessment and review process of their trainers, but I suspect that they're still working to enhance that system. It certainly is the House's desire to make sure that we're spending our resources really well there with effective trainers. But we may want to engage directly with the Post Board to follow up on your questions, Senator.
And that's fine. I can do that offline as well, Mr. Chair. And I was just, I know last year when we talked and put the bill together that was passed, we talked about I think it was warrior training, and maybe you can correct me if I'm wrong. We did away with that, and that certainly made sense to me. My next question, Mr. Chair, if I could, is the public assembly response. Public assembly response. What exactly does that mean, and where would that be requiring law enforcement statewide to have such a response?
Senator Ingebrigtsen. So this is, I believe you're referring to the model policy for public assembly. The Post Board is actually most recently in their meeting moving forward with that initiative. Obviously, as legislators, we want to be able to act statutorily as well. We certainly did that 2 years ago with the sexual assault investigations, where the Post Board made movements in the, using their rulemaking authority. And then we, both the House and the Senate, both sides of the aisle, thought it was real wise to put that in statute. But my understanding, Senator Ingebrigtsen, is that pretty much every department has policies around public assembly. So these are First Amendment protection rights, right? Not unlike other model policies, there may be differences in terms of that. And I think one of the things that we look for in our state is not to have a uniform policy as much as to have core standards that all departments ought to be adapting and adjusting their policies to in order to meet, the realities on the ground, but nonetheless, to be held to a consistent standard around public assembly. And so, one of the things that the Post Board has some ability to do is to do a constant review of the actions stemming from the policies of each of these law enforcement units. Kind of hard to do, if the standards are all over the place. So the idea here is to establish a high quality set of standards, and just like every other model policy that we do, then expect our law enforcement units, agencies to meet those standards, but not direct them necessarily to have the identical language as much as to demonstrate that they're meeting the standards. So pretty pro forma in terms of how we've done model policies in other areas as well.
Okay, and if I could, I've got several more. I don't want to take up all the time here, but I do have, with regards to the community safety grants, Mr. Chair, and crime victim survivors, 10 million and 12 million, and then the $40 million for community advocacy. Can that be? Can you explain a little bit more what community advocacies or advocates mean, or how would you disperse those dollars? Can you give me an example of that?
Well, there's several. So there's several accounts that you're identifying here. Right. In one category, we've got the supports for victims of crimes, including especially sexual assault. So those proposals came forward from Mincasa and Violence Free Minnesota. The governor wrapped those up in his proposals. We adapted them further with House language. So that's one category of grant funding. The other category of grant funding is for those more what you referenced, I think toward the end, which is community-based responses to violence. What we're looking for is the ability to open the door so that all communities can participate effectively. And so there's several components that we have here, the creation of essentially a navigator within the Office of Justice Program that can follow a process of opening doors to new communities, make that accessible for them, provide guidance for them. There's certain criteria around which these communities would be eligible based on crime incidents, based on demographics of those communities, processes by which they can have this coordinator work with a board within the OJP to be able to carefully assess the applications of these community groups. I mean, everyone's going to be held to a high standard for sure. We're talking about state resources here. The issue is that so many communities don't have a way to connect with the current grant programs that exist. So we want to make that much more accessible to communities at the same time that we're expanding the ability for more communities to participate in their own public safety.
Thank you,
We can also spend, we definitely spend more time walking through that much more carefully as well in the coming days.
Thank you very much, Mr. Chair.
Of course. Oh, very well. Senator Matthews.
Thank you very much, Mr. Chair. Couple things quickly. I got a text during the meeting that I don't think one of the staffers on the House side, on the House GOP side, had gotten in, Mr. Hallquist. Hopefully that was a mere oversight. If we could correct that for today and moving forward, wanted to make note of that. And then wanted to ask a policy question quickly on the expungement sections in the House language that I think were mentioned in a sentence or so in passing. My notes are correct. Article 14 and section 36, I believe that was chapters Mr. Johnson was going over. But if we could spend just a minute and delve in a little more on what those are doing, I would appreciate that, please.
So Article 14, section, what again, Senator Matthews?
I believe section 36 and following, and a few sections following. Yeah, I think it's on a page R30 in that section.
And Senator, your inquiry?
If either you or Mr. Johnson or whoever covered that section could give maybe a deeper overview of the expungement languages for a minute or so.
I see. Okay, and I don't recall whether that was Mr. Johnson or Mr. Debo, but let me call them out and see if who that might be.
Mr. Chair, it was me, Mr. Ben Johnson.
Very well, Mr. Johnson. I think the senator is looking for more detail around the that particular section, and he may have much more detailed questions. But
understood, Mr. Chair. Mr. Chair, Senator Matthews and other members of the committee, I'll walk through in a little bit more detail section 37 of what article are we in here? We're in Article 14. This is the automatic expungement of records. What this provision does is it identifies records that would be eligible for an automatic expungement. It includes records where cases have been dismissed, places where a person's been arrested but no charges were ever filed. It also includes several different types of crimes where a person has been convicted of misdemeanor, gross misdemeanor, and a small number of felonies. What it does is it makes those people eligible to have their records expunged automatically. It tasks the Bureau of Criminal Apprehension with reviewing records and identifying when someone is eligible to have those records expunged. The eligibility depends on the underlying charge, how long you have to wait. There's an applicable waiting period depending on the type of charge. After the waiting period, if the person has not committed a new offense during that period of time, records are expunged automatically. If you need more detail in terms of the list of offenses that qualify, I'm happy to walk through that, but that is the gist of how it works. Those would then be transmitted to the courts for orders. The orders would expunge the records and result in the sealing of both court records and records held by the administrative agencies. Mr. Chair, Senator Matthews, is that enough detail at this point?
Senator Matthews?
Mr. Chair, yes, that's helpful. I think I will hold it on that point, but thank you for the explanation.
Very well. And your first part of the question was regarding a staffer? I'm sorry, I was trying to.
I got a message. I don't believe Mr. Hultquist got on the Zoom screen. So I wanted to flag that for your attention.
You're talking about a House staffer?
Correct.
We have a House staffer attached to our minority caucus member on this committee. It sounds like you might have a relationship with another staffer. Perhaps you can encourage that staffer to contact me directly. Quite frankly, that's a House matter, not a Senate matter, Senator Matthews. Very well. Senator Latz.
Thank you, Mr. Chairman. I got a couple of questions about what we were presented with, just a little bit of a clarification. For the Human Rights Act Article 6, I don't have the section number, but it had to do with disability and the interactive process. Is that the provision that essentially incorporates into Minnesota Human Rights Act provisions that are already in federal law, but would give the Minnesota Human Rights Department the authority to get involved in employee situations that involve this interactive process?
Let me, Senator Latz, let me ask my colleague, Chair Becker-Finn, her committee has the direct oversight of the Department of Human Rights to respond.
Yeah, thank you, Mr. Chair. So it's the same language carried by a bill that Senator Abler is carrying, and it basically adds that an employer may engage in an informal interactive process to identify the limitations due to the disability. So it's very similar, and I think this came out of, I believe there was a federal case, so it's closely related, but I can't say for certain whether it's exactly what the federal law is.
Senator Latz?
So my understanding is that there was a provision, and maybe Commissioner Lucero can clarify as well, that the federal agencies have the authority to get involved in these local cases because they have that interactive language in federal law, but we don't have it in state law right now, which means that our state agency doesn't have the authority to get involved in that or to assist in that process. Is this a provision that's being utilized here?
Let's see if Commissioner Lucero is still with us here.
Thank you, Chair Mariani. Senator Latz, that is correct. The interactive process is built into the federal law, and there was some case law that came out in Minnesota that took that requirement out. And so this puts it back in. That state court case is McBee v. Team Industries. And so this clarifies and puts that alignment in that, in fact, the interactive process is required and is as part of, good collaborative interaction between an employer and an employee.
Okay. And then,
Senator Latz.
Mr. Chairman, Commissioner, then failure to engage in that interactive process would then be a violation of the Minnesota Human Rights Act, as it is now a violation of the federal disability discrimination laws. Is that correct?
Commissioner.
Thank you. Senator Latz, engaging in the interactive process would be a requirement under the Minnesota Human Rights Act, like it would be at the federal level as well. Yes.
Thank you. Mr. Chairman, a separate question in Article 7 on civil law, there's a reference to storage unit removal modifications. Is that the stakeholder agreement that's included in the House language then between legal aid and the representatives of the storage units themselves and so on? I know they've been working on that project for a couple of years. And is that the language that we're referring to here?
Let me defer to my colleague, Chair Becker-Fit again.
Yeah, thank you, Mr. Chair. Yes, Senator Latz, it is the compromise language between all the involved parties that legal aid is supportive of.
All right.
Senator Latz.
Thank you. I just want to make sure that I'm thinking of the right provisions because I know that the storage unit owners who have their own lobbyist representation and legal aid and others have been working on those provisions for a few years. And so it's nice to see that it's hopefully moving forward here. And then my last question for right now has to do with Article 14, Section 11, what was described as the military veterans resentencing provisions. Is this the Veterans Restorative Justice Act provisions as they've been modified along the way? Am I looking at the right? Is that where this language is contained?
I believe that's correct. I don't know if my Chair Becker-Finn might. We both vetted this provision. What section again was that?
Article 14, Section 11.
Mr. Chair, this is Ben Johnson. I could clarify.
Thank you, Mr. Johnson.
Mr. Chair, Senator Latz, that is correct. The language that is in the House bill is the language that's been moving throughout this session in the House. The language that is in the Senate bill is newer language. I believe the Senate language is based on the original language that was introduced. There was a fairly significant rewrite that was done in conjunction with, I believe, both some members of the Senate and some members of the House. That rewrite was adopted in the House. So that is the Veterans Restorative Justice Act language.
And Mr. Johnson, there were several important distinctions that remain then between the House and the Senate on this.
Mr. Chair, that's correct. There are some pretty substantial technical differences between the language in the two. The underlying policy is similar, but there are some significant, probably 5 or 6 significant policy differences between the two provisions.
Senator Watts.
Thank you, Mr. Chairman. I kind of assumed that was the language, but it wasn't initially referred to as the Veterans Restorative Justice Act. So I want to make sure I know what we're referring to. Mr. Chairman, the differences between the House provisions and the Senate provisions are very substantial. The language in the House bill reflects broad stakeholder agreement. There is support from defense veterans organizations, from prosecuting community, from the defense community, and quite a few groups have been working on that language for several years. It did go through a Senate review. We did hear that language in an informational hearing in Senate Judiciary and reflected a substantial technical revisions from Senate Counsel Backus as well, which was then incorporated into the House language when it was finalized and put into the House bill and moved forward. The language that's in the Senate bill is much more narrowly focused. And in fact, I would argue it's so different as to move existing veterans court practices backwards, not forwards. And as far as I'm aware, has absolutely no organization supporting it. It's got a number of provisions which I would kind of describe as poison pills in terms of their efficacy, the purpose of the Veterans Restorative Justice Act in the first place, including allowing the discretion for prosecutors to not offer stays of adjudication, which is exactly the problem that exists in current law that is attempting to be solved by the Veterans Restorative Justice Act in the first place. And it carves out, excludes some very substantial crimes from coverage, which would also, some crimes which beg to be included in Veterans Court or in these provisions because they reflect so deeply the need for this special kind of care and attention that the veteran needs within the process. So I would just ask, as we move forward and think about this, that the language that ended up in the House bill in the Senate bill with almost zero description on the Senate floor. And certainly no understanding, even at the level that I've just explained it, does not reflect a stakeholder agreement, has zero stakeholder support. And I'm informed from the veterans groups and others that they'd rather see nothing than see that language. So as we start thinking about what to do with that, I would encourage members to look at the House language and I think the Senate language in this one is a non-starter, and it doesn't accomplish the goals that are being sought by, I think, any of the groups that are attempting to move forward in this direction. And I'm not casting aspersions or laying blame. I'm just saying that the language came from a different place and are counterproductive and don't move us forward in any way. So I guess I'm just laying the foundation on that particular provision since it was identified today. Thank you, Mr. Chairman.
Well, thank you, Senator. And let's see what we might still be able to make of this. This provision's been around for more than one session. I know there's been a lot of earnest effort put into it, a lot of tough, back and forth exploration, discussion. It would be a shame if we got it this far and we can't move it any further. But on the other hand, I certainly don't want us to move policy that's A, not effective, and B, that doesn't enjoy the most critical stakeholder support behind it. So to be continued. Thank you, Senator Frazier, or rather Representative Frazier.
Thank you, Chair. Not quite Senator at this point, but thank you. This is Commissioner Harrington still
on? Commissioner Harrington, are you here?
Yes, sir, I'm here.
Oh, yes, he is.
Thank you, Chair. Thank you, Chair. Commissioner Harrington, you did kind of at the tail end of your testimony, you did kind of get into the discussion around the traffic stop bill bill and language that we have in this omnibus bill. And you said a couple of things that I just want to make sure I'm clear on it. It sounded like you were saying that we want to make sure that we don't have inconsistencies in what the rules are and how individuals, what they're getting stopped for from jurisdiction to jurisdiction within our state. And if that's true, I want to get some clarity because this bill would actually make it uniform across the state in terms of what officers are allowed to pull folks over. So I just want to get some clarity around that piece, and then I have another question after that. I just want to get some clarity on that. Is that what you were saying, or you were saying something differently than that?
Commissioner.
Chair Mariani, Chair Limmer, Representative Frazier. I did say that and said it because I'm supportive of the bill. We are absolutely supportive of your bill and getting this bill passed and signed into law because we do want consistent enforcement across the state. And we don't want a patchwork of different policies, department by department. We really do want to see a statewide initiative, and your bill is our best effort at doing that. So I said that in support of the bill. I'm sorry if it came off as I was saying it in a different fashion, but the Department of Public Safety and the Governor's Office are all absolutely supportive of the traffic stop policy bill that you have crafted.
Well, and consistency is certainly important on this issue. I can just imagine driving from one. It's a big state. I've driven it many times, and there absolutely should be a consistent application of many of our laws, particularly this. Representative Frazier.
Thank you, Chair. Thank you, Commissioner Harrington. No, I believe that you were supportive. I just wanted to clear that up in case it sounded otherwise to those that are watching publicly. So thank you for making that clarity on the record. My other thing is, I just want to say, in terms of this bill, it will add that consistency, but we also know the data shows us that when these type of policies are put in place, we actually see traffic issues go down. And then officers are actually able to focus on more serious crimes that are happening with moving violations or in other areas of that jurisdiction. So this is something that just it just makes common sense, and then also it's going to be just better overall for all Minnesotans if we put this in place. And it does have very broad support, bipartisan support, and also organization and corporate support as well. So I'm looking forward to seeing it get to the finish line and seeing the governor sign this and put it in law to make things better for all Minnesotans. Thank you.
All right, very well. Thank you, Representative. Anyone else? Okay, I'm not seeing anyone else at this point. And so what I'd like to do then, Senator Chair Limmer, is to move on to the next agenda item. Is that okay with you?
Yes, I did have a brief question or a statement to ask. I know that we have quite a bit of a difference between the two bills. I was somewhat surprised that our research staff could review 360 plus pages in about an hour. I was following along in the House document, House research on their overview, and I could almost read identical in the lines on the brief overview, which had 78 pages describing the 360-page bill, with a much more abbreviated version from your research staff. I suppose we'll have to review this a little bit more as far as specific language is concerned in the bill. And we may have to do that in the next few days. It is a big document, hard to digest the whole thing in a brief exclamation of what it is. Certainly within an hour is probably not adequate. We like to go through details in the Senate and look at specific language, make sure that there's balance. So if there was a court case that is triggered by some violation, that there's at least a clear defining moment for a court to make its decisions, as well as a proper definition. There's a number of definitions we've talked to. We probably don't have time in the next 25 minutes to do that, but just put us on notice. We're going to be, at least the Senate will be asking a few more detailed questions. I think Senator Latz certainly raised a good discussion on the Veterans Restorative Act, which is also carried in the Vets Bill, that same language, or the Senate language. So, so that's dual tracked, but nevertheless, we've still got a lot of detail work to do, as I would hope you would agree with, and we'll just keep on going. But just wanted to make that on the record, and we can proceed in the next section that you have, Mr. Chair.
Yeah, no, I appreciate that, Chair Limmer, and I think what you're articulating is absolutely appropriate for a conference committee to do its due diligence and understanding all the provisions before it. Please know that if there's anything in particular that you or your members want to focus on, we can direct our time together, as well as when we're not together in terms of getting information, because we do certainly want, strong common understanding of what's before us. Members, one of the things I was struck by, even beyond what we had in the side-by-side, was the thoroughness of our nonpartisan staff in highlighting a number of provisions where the provision was not present in the Senate, but certainly present in other bills, some that are sitting on the Senate floor, awaiting second reading, others that have passed through other committees. So that's helpful to know. It means that there's some level of constant good quality, vetting happening across both our bodies. And, I want to say then, the glass is half full, not half empty when it comes to that. But no doubt there are new provisions here relative to the Senate's not having, spent time and looked at those. And so it's absolutely appropriate for us to slow down and make sure that we're going over that ground with a little bit more detail. It's an absolutely appropriate function for a conference committee to be doing it. And Chair Limmer, you and I can, organize, I'm pretty sure efficiently on how we can make that happen for our members. All right, very well. So let us then move on to the next section of the agenda. And I'm going to call on my colleague, Chair Becker Finn, then to walk through, walk through this first offer of the House to the Senate.
Thank you, Mr. Chair. And I'm going to share my screen in a minute, but I welcome your comment, Senator Limmer. I think, this initial offer is focused on same and similar provisions and a couple non-controversial items that were carried on the civil law side. And so I think, this is potentially a good way to move forward and get some of these things off of our list where we, I think we do have agreement. And so I'm going to share my screen now, and we can walk through this. I believe staff is also going to email it to everybody as well as post publicly for folks to see. All right, is it up on your end?
I see it. Okay,
great, very well. So it's 8 provisions total. It is, so number 1 is actually is House File 1080, Senate File 875, which would prohibit discrimination against persons with disabilities seeking organ transplants. This is on second reading in the Senate and is included in the Senate HHS Omnibus, and we're proposing the House language, which is slightly different. Item number 2 would be the Uniform Probate Code harmless error provision sunset removed, which was a Representative Long, Senator Johnson bill. You guys already passed this off of the Senate floor. It's sitting on the General Register over in the House. So obviously, we think there's some support there. Number 3 is also sitting on the General Register and is passed off the Senate floor, that is classifying DNR data on minors as private. That was something that I carried, as well as Senator Rude. We'd be proposing the Senate language. Number 4 would be modifications to the Safe at Home program, which is also a bill that I carried and that passed out of the Civil Law Committee, carried by Senator Bigham. We would be proposing the House language. Again, these are all things that we just walked through earlier, but this is just those updates to the Safe at Home program to make it work better for the folks who need it. Item number 5 was a permanent change to in-person application requirement for marriage licenses. We would be proposing the Senate language. This was another bill that was carried by Senator Bigham and is on second reading over in the Senate. It was carried by Representative Hewitt in the House. Number 6 would be the modifications to access of birth and death records, which was a Representative Cleavorn, Senator Duckworth bill. We would be proposing the House language, although I believe they're very similar. And this is, I think, has been carried in a couple different places. It's one of those crossover things where it's also an HHS priority as well, but we had carried it in our bill as it has to do with data. And then the last 2 are things that have not necessarily moved on your side of the aisle, but we really do think are non-controversial and hoping that you see it that way as well. And one of them is the question that Senator Latz was just asking about the interactive process required when interacting with individuals with disabilities. This is carried by Senator Abler and Representative Ryer in the House. And then finally, the Ombuds for Corrections Data Practices Modifications, which is carried by you, Senator Limmer, and Senator Tu Zhang in the House. And that would mirror the House language that we currently have in this bill that is literally just changing one thing. So it is more narrow than what was individually introduced, would just make the name, location, and identification of the person, would make that not public until after the case is closed. So that those are the provisions. And again, you know, I spoke with Senator Matthews this morning about these provisions, and you know, we're just really hopeful. I think these are things that your members want to see get done, our members want to see get done, and I think you know, want to get us off on the right foot and you know, honestly show the public that we are able to get some work done, even if we do have some stronger disagreements in other areas. And so with that, I believe how staff has already emailed this out to everyone as well. So I'm going to stop sharing my screen and am happy to answer questions or hear reaction from Senate members.
I'm sorry, Chair Limmer, I think you're muted.
I think I'm on now.
There you are. Yeah, yes, you are, sir.
Chair Becker-Finn, I had a question. I don't have the document in front of me right now, but I think it was question number 3. The reference of DNR. What does that mean? What's the definition of DNR in that context?
Oh, thank you, Chair Mariani. So the Department of Natural Resources data. Okay. It's the relating to different data that they keep regarding when kids take firearm safety training or participate in other programs through the DNR. We're just making sure that minor data is classified as private, because right now it currently isn't. So this is something that passed off the Senate floor, carried by Senator Rood.
Okay, I didn't know for sure what the DNR stood for. Could be do not resuscitate, you know, and so just wanted to get a clarification there. I think it means something else in other occupations, so I don't even want to go there. So
that comes later, Mr. Chairman.
Yeah, I bet it does. We might all be welcoming.
Yes, we'll have to find someone to resuscitate us.
I think after they hear 10 days of this, we may not find any volunteers for that. Are there any other members that have questions? And the reason,
looks like Senator Matthews, right?
Yeah, thank you, Mr. Chair. And thank you, Representative Becker-Finn. We did talk this morning. I am going to bring the list, have more conversations on it. I almost literally had meetings jam-packed since our phone call, almost right up till committee. But we'll go through it and going through it with our staff on this side, and we'll definitely get back to you on that, but appreciate you reaching out on this.
Very well. Anyone else?
Mr. Chairman.
Yes, Chair.
I'm sorry, I don't have a hand on my lower bar, so I just have to interrupt and barge my way into a conversation.
It's under the reactions button, Senator Limmer.
The reactions button? Oh.
It disappears if your cursor isn't on the, I had to learn that the hard way.
There. Thank you, Senator Matthews, for that guidance. As you know, we just literally received the offer. We'll have to get back to you. We'll review it. And so all we have to do is decide on those and we're done.
You know,
I wish it could be that easy.
That's kind of tempting.
Yeah, it is. We'll look it over. We'll get back to you soon, and we'll see how it fits in with all of the other subjects that we have to deal with.
Yeah, of course. Yeah.
But thanks for putting a focus on it, on these items.
Absolutely. Thank you, Chair. And you and I have been through this a number of years. And, you know, I do think it's important that we show, you know, to one another, but also, you know, to the public, you know, that we are, in fact, not just banging heads, but, you know, we're also, you know, steadfast in moving forward. And so we want to be able to show some common, you know, steps that we can take forward and reassure the public that we'll get this thing done. Chair Becker-Finn, and then Representative Miller.
Yeah, thank you, Chair Mariani. And yeah, I just want to reiterate that, you know, the intention wasn't to catch anybody off guard. And I totally understand that folks would want to take some time to look it over and make sure that things are square with our understanding on the House side. But would just welcome any of the senators to reach out to me if they do have questions. I'm very familiar with all these provisions, and you know, I know that there will be more heated moments and more difficult items that we will work with in this committee. But I do think, you know, to echo what Chair Mariani just said, I think this is the kind of thing that the public expects us to still be able to work together on, and welcome the ongoing discussion and feedback from senators.
Very well. Representative Miller.
Thank you, Chair Mariani. I have just a brief comment when we're wrapping things up. I don't know if this is wrap-up time yet or not. I can wait if there's any more to cover on Chair Becker-Finn's portion.
I think we're done with that. And the Senate is indicating that they'll look at it and they'll get back to us soon on it. And that's pretty typical when we have offers. So.
Yep. Yeah. Okay. Well, Chair Mariani, all I was going to say is, and this is not going to be popular to the people that are on here, but this year being different, as we've said many times, and we have this very structured 3-hour meeting every day, this is nice. And I know that we're being told there aren't going to be other times, but I think Senator Limmer, Chair Limmer, stated it well. There's a lot to cover, and I'm concerned about the time constraints. And so I would just encourage the leaders of this conference committee, in whatever way that you discuss with leadership in the House and Senate, we need to be prepared that we may have to carve out some other times if we're going to give true attention to some of these very important issues that we're going to be talking about.
Yeah, that might well be the case, Representative Miller. I mean, obviously, we've got some constrictions. They're new to both me and the chair. I suspect everyone here. But I do know that part of the ethos of both houses is, you know, whatever it takes, you know, to get things done. And so we may well be communicating with our leadership about, you know, if we need more formal time in public to be able to carve that out. Obviously, I haven't spoken to you, Chair Limmer. I'm just thinking out loud here. And I also think that, you know, the chair and I can work to at least create some ways in which some of our members can team up and do some work. That's also a typical practice in conference committees where, you know, maybe 2 on each side or 1 on each side might, you know, go off to the side and see if they can work out some language together to bring it back. And so, Senator Limmer, you and I probably need to start thinking about that and communicating. You know, I should be communicating with you and you with me about, you know, our desire to do something like that. You know, perhaps the veterans piece might lend itself to that. I don't know, but you know, I think we may have a couple of creative ways in which we can maximize our time together. All right. Well, I think I didn't quite one up the chair, but it looks like I'm going to finish ahead of time here today. Senator Limmer, I take it we're still on for tomorrow. And I know that there was talk of having the commissioners come, and so you are muted again, sir.
Yeah, I found the button this time. 9 a.m. will be our starting time, and we have our commissioners to give us comments about the two budget proposals. And I'm sure they'll revisit how that money would be spent in their minds and what difficulties that the other proposal would cause them. We need to know that. We still don't, as you and I both know, we don't have new budget targets at this time.
That's right.
So it's kind of getting to know you time and in both bills. And it looks like we're going to have to visit a little bit more on the policy additions that you all have. So,
all right.
See you all at 9 a.m.
Very well. With that, members, we can end today's meeting and be back at it fresh in the morning. So until then, this committee will stand adjourned. Thank you all.